Hello everyone, I welcome you back to our channel. This is Legal Mindset Adeva, and today we are going to look at an interesting topic in constitutional law. So, if you want to understand all questions of constitutional law and all other questions of those of legal methods, this topic cuts across administrative law, the topic of supremacy of the constitution. You should understand it. This topic is keen to all those students. So I beg you to subscribe such that I start taking you through the supremacy of the constitution. Okay, if you want to attempt the supremacy of the constitution very well, I urge you to look at Article 2 of the 1995 Constitution. As a must, every law student should know this article because it tells us of the binding force of the 1995 Constitution being the supreme law of the land. And Article 2, Clause 1 of the 1995 Constitution states that the Constitution is the supreme law of the land and it shall have binding force on all other laws and all people of Uganda. If you continue to Clause 2 of Article 2 of the 1995 Constitution states that the Constitution is the supreme law of the land, and if any other law or provision or custom or norm is inconsistent with the provisions of the Constitution, that other law, custom or norm shall be inconsistent and shall be rendered null and void to the extent of its inconsistency. So, I'm going to take you through a number of authorities, a number of cases which have brought up the binding force of the Constitution, emphasizing that the Constitution is the supreme law of the land. To begin with, the case of Pokawanga Semogere versus Attorney General, case number 3 of 2000. Court held that the Constitution is the supreme law of the land and shall have binding force on all people, and all other laws shall derive their mandate from the Constitution. If any other law is inconsistent with the Constitution, that other law shall be void. If we continue, the case of Major General David Tinyefunza versus Attorney General, Justice Kanyei Amba clearly stated that the Constitution is the supreme law of the land and subjecting Tinyefunza to forced labor against his will. Remember, Tinyefunza had requested for resignation. Justice Kanyei Amba stated that maintaining Tinyefunza in the army without his will was against Article 25, Clause 2 of the 1995 Constitution, which calls for protection from forced labor. So, that was the principle in that case. Because if it was maintained in the army, it would be against Article 25 of the 1995 Constitution, which prohibits a person from being subjected to forced labor. If you continue to the case of Andrew Mwenda and others, and another versus Attorney General, case reported in 2008, Andrew Mwenda and another were being convicted of seditious offense and seditious intention, talking bad about the president. But court went on to say that convicting all, sentencing Andrew Mwenda and another of seditious offense and seditious intention relating to Article 39 Clause 1A and 41 subsection 1B. Those are sections. They were the sections of the penal code which talked about seditious offense and seditious intention. They were inconsistent with Article 29 of the 1995 Constitution, which gives all persons freedom of speech and expression. If you say that if you talk bad things about the president, you are limiting a person's freedom of expression, freedom of speech. Therefore, Section 39, Clause 1A, Section 39, subsection 1A of the Penal Code, and Section 40, subsection 1B of the Penal Code were scrapped off, were rendered inconsistent and void, and we no longer have the seditious offense and seditious intention because they are inconsistent with Article 29 of the 1995 Constitution, which mandates for freedom of speech and expression. If you continue to the case of the women lawyers versus Attorney General, the women lawyers were against Section 4 of the Divorce Act, which much favored a man against a woman when it came for divorce matters. And remember, Article 21 of the 1995 Constitution stipulates and emphasizes equality before the law. So, Section 4 of the Divorce Act did not foster equality before the law because it favored a man against the woman, and it was scrapped off, it was revised, it was replaced. Now, if you go to the case of Salvatore Aboki and another versus Attorney General, Salvatore Aboki was convicted of witchcraft and he is co-accused. So, they were chased away from the village, their property was destroyed, and their gardens were confiscated. Doing this, it threatened their life to life. Because if a person does not have shelter, a person does not have where to live, a person does not have where to get food, how can they sustain life? It was against the right to life in Article 22. It was also against Article 28 of the 1995 Constitution. Clause 7 and Clause 8 call upon the law to be clear. The law must be clear. And Section 3 of the Witchcraft Act was not clear of what amounts to witchcraft. So it was scrapped off. It was rendered null and void. So that is the supremacy of the Constitution. The Constitution is the supreme law of the land. Article 2, in summary, all law students should do, put in their heads Article 2, because all other laws derive their power from Article 2 of the 1995 Constitution. For those of you who regard private mentorship, private tutorials, our numbers are down in the description box. We have connections of experts in various course units. Do not fear to contact us. Any question, any challenge, you can reach out to us. Thank you very much. This is Legal Mindset at the Bar.